Hey everybody, welcome back to the Court of Random Opinion. My name is Laura Neidigh, and for this crowd, welcome back to the internet where your cesspool is my jacuzzi. Not long after Clayton Echard had just filed his response to Laura Owens' motion for reconsideration to the appellate court in her fake pregnancy case, the Court of Appeals has already ruled. Laura Owens has now lost again in the Court of Appeals. Of course, we know they intend to keep this ball rolling, because that's not enough. She needs to lose in a higher court, I guess. Anyways, I had just recorded a recap of the document that Clayton had filed in response, and as I was finishing that up, the court just made this decision. So I wanted to edit this in, but I am going to go ahead and play for you guys the recap that I just did, so you can see what Clayton had to say in response to Laura's motion for reconsideration. After an embarrassing loss in the Court of Appeals, Laura Owens still can't take no for an answer. She recently filed for reconsideration with the appellate court. My good friend Schnitzel Ninja was actually the first person to break this story today, so I am going to leave a link in the description of this video to her channel where you can hear her read this document in full. I myself am going to skip over a lot of the legalese and just add some snark. If you're new to the channel and you're not familiar with this case, Laura Owens falsely accused the bachelor Clayton Echard of fathering her twins. As it turns out, there were no twins, and Laura Owens has been victimizing men with this same scam for at least a decade. Owens admitted to altering medical documents in her deposition. She changed her story on the stand the day of trial, and she's still digging in, writing fantasy-filled manifestos that are a turd stain on the American justice system. Last night, I went over her latest manifesto on Medium.com with my friend Bruce from Oregon, and you should check that out. I'll put a link in the comments below. If you want more backstory on this case, you can check out the whole Owens versus Echard playlist, which I'll also link in the comments. Anyways, here's my recap of this latest document. Now, as I said, this is a response to Laura Owens' motion for reconsideration, a carefully crafted document which was made by her attorney turning on voice-to-text and then farting into his dictation device. Now, here's the response. On April 11th, appellant Laura Owens filed her motion for reconsideration. On April 15th, the court issued an order taking the motion under advisement and setting a deadline for appellee Clayton Echard. Laura's motion offers two arguments. One, the court's structural error analysis misstated Arizona law, and two, reversal is mandatory because the trial court failed to make the required statutory findings to support an award of fees under ARS 25-324 or 25-809. The preamble to Laura's motion states that reconsideration is not an appropriate vehicle to rehash arguments previously raised and rejected, and Laura will not re-raise the same legal arguments this court has already considered. But that is mostly what she has done. Kind of like I said I wasn't going to sit here cackling through all of my readings of Laura's motions in these cases, and yet that is mostly what I have done. In fact, arguments that were not previously raised cannot be made for the first time in a Rule 22 motion. A Rule 22 motion can allege error in the appellate decision, of course, but it cannot make new arguments that could have been offered in the trial court or appellate briefs. If Laura's assertion is true and only new arguments are raised, then the court can stop reading after the first page. Part of the motion, on pages 2 through 5, alleges the court misinterpreted the law. Yes, the strategy for Laura and her attorney in these things appears to be try to convince other people that they are wrong and stupid, rather than look at what you're doing and see where you might be going wrong after losing every single time. Of course, can we really be surprised from the man who sat there and got schooled by Rachel Juarez, who knew the cases that he cited in his brief back and forth, and all he could do in response was offer her a fucking cookie. But hey, after the man wrote in an actual court filing a disparaging rant about Judge Julie Mata, which actually included the words, "Look at me, daddy!" Who could be surprised that that's how he conducted himself? Moving on. Clayton disagrees and explains the law below. Well, someone should. The remaining sections on pages 6 through 18 allege new arguments that were not raised or developed in the briefs despite being available to Laura before the memorandum decision. Clayton briefly addresses these arguments, but categorically objects to the consideration of new arguments that were either never raised previously or were not properly developed in the trial court or appellate briefs. This court cannot condone the relentless reframing of arguments that were either already rejected, not raised below, or not properly developed until the current motion. Like any other litigant, Laura strategically decided which arguments to bring and which to abandon at each stage of the proceedings. When an appellant strategically devotes limited space in the opening brief to arguments lacking legal merit, they must accept the consequences of that decision. Unfortunately, as we know, when it comes to accepting the consequences of her decisions, Laura usually just calls the FBI. And of course, yesterday we learned that she is still filing random frivolous police reports against Clayton Echard for existing online. When a man says he doesn't want to be with you outright after one night of only oral sex, and then won't sign the dating contract you try to force him into when you threaten and harass him with fake twins, I can't imagine why he wouldn't be throwing himself at you after you continue to call the police because he doesn't want to be with you. Alright, we're moving into the discussion here. A, the court properly held that structural error analysis is inappropriate and actual prejudice must be shown to warrant reversal. Laura argues, just as she did in the briefs, that a judge considering extrajudicial or ex parte evidence is per se reversible error. Not even a manual says that. And the quote here says, "We agree that the rule that a trial judge must be impartial does not mean that a judge must recuse himself from a criminal case merely because he has heard unfavorable remarks about the defendant in the course of prior litigation." The motion relies on cases addressing the substantive analysis of a bias claim, not per se reversal. Laura argues that the court erred because the ruling relied upon an erroneous application of Arizona law, and that, in fact, the cited authority requires reversal. Specifically, Laura alleges the court misstated the law when it cited State versus Emanuel and Stagecoach Trails, MHC LLC. For context, the court declined to apply a structural error analysis given the record before us. The reason Laura argued so intently for a structural error analysis is apparent from the briefs and the motion. She can only obtain reversal if the court adopts a standard that does not require showing actual prejudice. This court correctly declined to apply structural error analysis, but that did not end the court's inquiry because reversible bias could still arise outside of the structural error context. The ruling correctly cites Emanuel for the proposition that a trial court's reliance on extrajudicial information may give rise to a claim of judicial bias separate from a structural error claim. Emanuel was not a structural error case and does not discuss or apply that standard. Next, the court cites to Stagecoach Trails, specifically paragraph 21, for the proposition that the critical inquiry in a prejudicial bias analysis is whether the conduct demonstrates an extrajudicial source of bias or deep-seated favoritism. This is precisely what Stagecoach states. Judicial rulings alone do not support a finding of bias or partiality without a showing of an extrajudicial source of bias or a deep-seated favoritism. In fact, that entire paragraph in Stagecoach is a collection of nested citations from other cases articulating the general types of evidence and standards necessary to prove reversible bias, not per se reversal under structural error analysis. These cases do not support the idea that prejudice must be presumed, except in the most extreme circumstances. This court already addressed these arguments and found Laura failed to even properly argue prejudice, much less establish it to such an extent that requires reversal. The motion does not raise any valid basis to revisit the memorandum decision, and resolving the appeal on new grounds raised in a Rule 22 motion would visit tremendous inequity on Clayton and his right to due process. Moving on to B, the court did not err in finding attorney's fees were appropriate under ARS 25-324, 25-809, and 25-415. Laura argues in her motion for reconsideration that Clayton's motion for leave to amend withdrew his request for fees under ARS 25-809, and that because the parties spent no time litigating parenting time, and the trial court never made the specific statutory findings, Clayton was not entitled to fees under ARS 25-324. To the extent these arguments are raised now for the first time, they cannot be considered. Moreover, in so arguing, she misstates the record and relies on an inapposite, unpublished decision in Kent versus Kent. This court already decided that the trial court did not err and that the awards would be upheld even if the trial court did not cite the most correct authority. Laura further claims that Clayton cannot be awarded fees under ARS 25-324 because the trial court never made the specific findings required after Laura requested findings of fact and conclusions of law under Rule 82. Laura relies on State v. Torres, but her argument ignores the basis for the holding in that case. In Torres, this court found that ARS 12-849 did not allow an award of attorney's fees to the state. Laura's misleading citation stops just short of the key parts of the discussion. Shocking. Shocking. Kind of like Laura's misleading articles and her attorney's misleading blog posts and videos stops just short of the key parts of all of this that show that Laura lied about being pregnant. The very next sentence after her quotation reads, if the legislature had intended to require a defendant in a paternity case to reimburse the state for reasonable expenses incurred in bringing the case, it could have so stated. Torres finds the fees award would have been proper had the prevailing party incurred any, but she was represented by the state and incurred no fees. The reason the fees were not necessary to the full and proper presentation of the action was because there were no fees. The statute did not expressly enable the state to seek fees in such cases, and this court declined to legislate the issue itself. Torres does not support Laura's argument the way she asserts. The trial court also awarded Clayton attorneys' fees and costs pursuant to ARS 25-415 because Laura Owens knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery. The court shall sanction a litigant for costs and reasonable attorney's fees where a false claim is knowingly presented or a court order compelling disclosure or discovery is violated. Because these conditions existed, the court properly held that the court made such a finding, thus it was required to sanction Owens, and that Owens did not meaningfully challenge that finding. As it turns out, the court doesn't like it when you just ignore discovery or present false information. Laura claims that Clayton never sought relief under ARS 25-415, and therefore she never had any chance to explain her side. This is false. And guys, even outside these court documents, this whole I never got a chance to explain my side thing is like such a pervasive excuse that she uses, even though we have covered her side to death. The fact of the matter is, her side is a lie. As this court notes, although 25-415 does not require the filing of a separate motion, as previously noted, Echard requested relief under this statute. Specifically, on March 11, 2024, Clayton filed a motion to compel Laura's compliance with Rule 49, Arizona Rules of Family Law Procedure, and to disclose, among other items, her purported Planned Parenthood records. On April 9, 2024, the trial judge granted Clayton's motion to compel. Still, Laura did not comply, and the trial court found she presented a false claim and knowingly violated a court order compelling discovery, such that an award is appropriate under ARS 25-415. Fees under this statute were therefore mandatory and appropriate. Laura had notice, opportunities to comply, and opportunities to be heard before relief was given. She cannot change tack and challenge the discretionary amount of the award now. Lastly, Laura now raises objections as to individual time entries. She alleges they were not related to any parenting time issues and should therefore have been categorically excluded. Any such argument not raised below is waived. Laura's objection to the China doll application appears at ROA 135. The objection disputes the fact of the award, arguing inter alia that the court could not award fees because Laura invoked Rule 26 safe harbor. The fees were for tort-based counterclaims, etc. She argued generally that the hourly rates were not reasonable under ER 1.5, but did not object to any specific time entries as she now does. She argued that the fees were not necessary because Laura intended to let the case be dismissed and alleged Clayton's desire to use this case for purposes of publicity and his counsel's wish for personal revenge against Laura were actionable abuse of process. And that is the most ridiculous thing I've ever heard. She's basically complaining that she can't just harass someone and abuse them in the court system and get away with it. She did not object to specific time entries or develop an argument as to the fees being unnecessary or causally unrelated to her conduct, as she now attempts to do. This argument has been waived. Regarding the time entries for consulting with entertainment lawyers challenged on pages 13 to 14 of the motion, Clayton's counsel learned that Laura once auditioned to be a contestant on The Bachelor and contacted the attorneys regarding producing her application materials for possible impeachment use. Investigating potential sources of information, including prior statements of a party, is especially appropriate when a party has not provided full and accurate disclosures, as occurred in this case. It is well within the trial court's discretion to award fees incurred for investigation relating to a party's missing, incomplete, edited, or inaccurate disclosures of information where credibility is at issue. The Court of Appeals correctly affirmed the trial court's ruling. Clayton requests the court deny the motion for reconsideration and grant leave for Clayton to file a supplemental application for attorney's fees incurred in responding to it. The court should also note that Laura did not timely file an objection to the application for attorney's fees and costs filed in this appeal on April 4th. Well, there you have it. These guys aren't going to stop anytime soon. They've already announced their intention to take this to the Arizona Supreme Court and the U.S. Supreme Court if they have to, as if the U.S. Supreme Court would ever waste their time on this. I'll be back with more news as it becomes available. Thanks for watching. Don't forget to hit the like on this video, and I'll see you all soon.